Hi, I'm Dr. Paul Moorhead, and I'll be leading us through this micro-teach on the subject of contract law, and specifically the topic of consideration. So consideration is a key ingredient when forming a valid contract. Consideration can take many forms, and the nature, the timing, to a certain extent the amount of consideration are all important aspects of a contract. They may make the difference between a contract being validly formed and enforceable between the parties and there being no contract at all. In today's session, we're going to look at two aspects of consideration. So firstly, let's remind ourselves why consideration is important in the first place. And secondly, we'll have a look at some of the key principles in relation to consideration and a few examples of the types of consideration. So firstly, let's refresh our memories about why consideration is important in contract law. The reason is that consideration is one of the key ingredients of a validly formed contract. For a contract to be validly created, there must be an offer. That offer must be accepted, and the parties must intend to be legally bound by the contract. And underpinning it all, we have to have consideration. Most contracts must be supported by consideration, but a notable exception is a contract by deed. Now, a deed may create a legally enforceable promise if it's in writing, it's signed, it's witnessed, and it's delivered. Now, of course, those four key components of a deed set it aside from being a normal contract, because a normal contract need not be in writing, nor need it be signed, and there's no formalities regarding witnessing and delivering a contract. So without consideration, English law will not uphold a bare promise, a promise that's not supported by something of value changing hands. An offer to do something with nothing in return is simply not enough to create a legally binding contract. So if I offer to go out and get you a cup of coffee, and I disappear and never return, I haven't breached a contract, because no contract was ever created. I made a bare promise, and you didn't do anything or offer me anything in return. So, on the basis that we now know that we need an element of consideration in order to create a contract, let's look at some of the key principles and some examples of consideration. Before we do, let's make sure that we understand some of the terminology that we'll be looking at later. So a bargain. A bargain is a reciprocal understanding or an agreement of some sort between two or more parties. We'll use this just to describe the process of reaching an agreement. We'll also use terminology in relation to a promisor and a promisee. A promisor, he's somebody who makes a promise. And a promisee, well, you won't be surprised to learn that that's somebody to whom a promise is made. There are a number of rules regarding consideration, which is not surprising when you consider that consideration is often the most arduous part of a contract. Also, countless contracts are created every day by commercially minded people. People who try to balance a whole range of different commercial, personal and practical factors in arriving at a contract. We all enter into contracts on a regular basis. A simple situation is, if you want a new mobile phone, you could either go to the phone shop and buy one for £300 or £400, or you could offer to pay slightly more in monthly line rental and get a free phone in return. So the phone shop owner is suggesting a different bargain to the one that you perhaps originally intend. he'll give you the phone no upfront cost if you agree to sign a 2 or 3 year contract to connect the phone to their network. So even in this very common and everyday scenario, we have commercial factors, we've got personal factors, and we've got practical factors influencing the way in which a contract is formed. Add to this the fact that the courts have been asked to rule on a myriad of cases over several hundred years, and you get a relatively complex set of rules regarding consideration. So let's look at some of the main ones in relation to consideration. So types of consideration. Consideration can be executory. In other words, promises are exchanged to perform acts in the future. For example, person A promises to deliver goods to person B, who then agrees to pay for them on delivery. Contrast this with executed consideration, where something is done by one party in fulfillment of a promise made by another. So, for example, person A offers a reward for information, person B then comes forward and provides that information. But both of these can be distinguished from past consideration, and we'll look at past consideration in a moment. So here are some key aspects of consideration. So firstly, consideration need not be money. It could be something else. It could be something for something. As long as it's something of value changing hands, then the requirement for consideration has pretty much been met. There's no need to write a cheque. It could be offering to do something or offering not to do something. Secondly, consideration must not be past consideration. So to distinguish this from the executory or executed consideration that we saw earlier, past consideration is not valid consideration. Past consideration is some benefit or service that's already been provided to the promisor. Whether it is past consideration or not depends on the facts. So in Re McArdle, a woman carried out work to a house owned by family members who then promised to pay her for that work. But she could not enforce that agreement because her consideration was already past. So the consideration must move from the promisee. So only a person who's provided consideration in return for a promise may enforce that promise as a contract. Here we'll also be looking at this later in privity of contract. So in Tweddle and Atkinson, two individuals agreed between themselves to pay some money to a third person. But when that third person tried to enforce the agreement against the executors of one of the original contract parties, his action failed because he hadn't provided any consideration for that bargain. Consideration must be sufficient, but need not be adequate. So consideration has to have some value, something for something, as we saw before. But the courts will not look into the quantum of that value in order to determine whether the consideration is adequate. And of course this is because a contract is freely entered into. If you remember, it requires the offer, the acceptance, the intention, and as long as we omit mistake, duress and undue influence, then there's no reason to look behind the reasons why the parties were contracting and the value that they placed on whatever was changing hands. The courts aren't concerned with fairness. We've also got an existing public duty, which isn't consideration. So, leading case here is Collins and Godefroy. A promise to pay someone to give evidence in a trial where the person had been subpoenaed was not consideration, as he was under a legal duty to appear in court anyway. Although this is probably a matter of public policy rather than a matter of strict contract law. Also, performing an existing contractual duty is not consideration. So leading case here is Stilkin Myrick, where two sailors deserted a ship and the captain of the ship promised the remaining sailors extra wages if they would stay and sail the ship. Now, on the basis they'd already agreed to do this under their existing contracts, the captain's promise to pay them extra wages simply wasn't binding. And we've also got part payment not being consideration as well. So this is the rule in Pinnell's case, a very old case, 400-year-old case, but still good law now. So that leads us through our gentle canter through this topic of consideration in relation to contract formation. We've looked at why consideration is an important topic, and of course because it's one of the crucial ingredients of a valid contract. We've also looked at types of consideration and what does, and perhaps more importantly, what doesn't constitute consideration in this context. I've referred to several cases during this micro-teach, and several are mentioned in the notes that run alongside this, and I recommend that you read these cases and ensure that you understand the reasoning behind the various decisions. The facts of the cases, whilst they may be easy to gloss over, are worth noting, as they will also help you bring to mind the decision when you need to remember it. And finally, if you'd like to review this micro-teach, the presentation with my commentary is available on the web address that's given there on the slide. Thanks very much.